Good morning, everyone. I would like to extend a warm welcome to all those who are with us and to those who are following the event through our networks. I express my gratitude to the experts, human rights defenders, representatives of civil organizations, and public authorities with whom we are working to build a stronger rule of law and greater access to justice in Mexico. I am pleased to welcome Anders Matthews, Deputy Director, Office of Governance, Human Rights and Citizen Security from USAID Mission in Mexico. I also extend a warm welcome to Maria Jose Salcedo, Mexico Project Coordinator of the Friedrich Neumann Foundation, a valued partner of our organization. I would also like to acknowledge the participation of our colleagues, whose perspectives will help us to understand and think outside the box about the possible solutions and to explore potential implications of an upcoming judicial reform, particularly for criminal justice, as we know. In a few minutes, I will introduce them. For the beginning, let me share with you some ideas. The subject of today's discussion is of the utmost importance. As it does every year, Mexico Evalúa conducts a comprehensive, meticulous evaluation based on official data on the state of criminal justice in our country. It is widely acknowledged that criminal justice is the government's primary responsibility. Without it, it is challenging to uphold a robust legal framework. Without it, our freedom and rights in a democracy are not guaranteed. Without it, we cannot achieve an inclusive society where all members are and feel included. Without it, we cannot build a sustainable peace process. Criminal justice is a fundamental aspect of any functioning modern society. It's through it where we can enjoy the most basic legal goods, such as personal freedom and security, family, integrity, and society. Justice is the foundation of civility. The world is currently facing several significant challenges. Some of these are outlined in the Sustainable Development Agenda, are inherently linked to justice. To achieve a more egalitarian society, for example, with security and peace and a healthy environment, it is essential to have justice in place. In this context, Mexico is undergoing internal processes of paradigm redefinition. We are in a post electoral period in which the incoming federal government has already defined its main commitments. Among them is a very important judicial reform whose impact on criminal justice is yet to be known and measured. But we already know that this reform is not trying to solve the many challenges that criminal justice still faces in Mexico, and from which you will learn today. Consequently, the insights, cautions, and suggestions we will present today are particularly pertinent. We are here to assess the key areas identified through our evidence-based evaluation, but we are also encouraged to collaborate on an alternative solutions and pathways that will enable us to overcome the main obstacles and trends we have today. From a people-centered perspective, we seek to encourage reflection on the next topics. The possibility of guaranteeing justice that is responsive to the needs and the priorities of the people, because people perception of justice is different, and the system needs to take that into account. Of guaranteeing certainty of due process and unrestricted respect for our rights, both for victims and defendants, of building a justice system that guarantees equality before the law and that is also capable of resolving conflicts, crimes, and dealing with threats to society. Today, in its third edition, we share the English version of our report, Hallazgos, to amplify the analysis and the conversation for those who are not Spanish speakers. In this way, we can amplify our message to different audiences, and who also wants to track what is happening in Mexico and can offer different views to our problems, to our lessons learned, and the experiences as well. Everybody is welcome to the conversation. As you will see in the presentation further, Mexico faces substantial challenges in criminal justice. We see with concern the absence of a state perspective, not only among areas of government, but also between public security and criminal justice efforts. Militarization has brought with it a neglect of strengthening civilian personnel and the skills necessary to guarantee the human rights of victims and accused persons. In terms of rights protection, the possibility of victims as accessing free legal advice is minimal. Let's not even say anything about their participation and assistance in the process. This is not only uh, this not only implies barriers to exercising their most basic rights, but also leads to processes that do not respond to their needs and priorities. A clear example is the percentage of cases in which repair is achieved. It is still minimal. A similar situation is observed in the cases of people accused of a crime. The possibility of having an effective defense is still remote. The analysis point to cases in which the defense acquiesces to what the Attorney General offices order instead of looking after the interests of its representatives. Furthermore, the proportion of people in preventive detention and the duration of this measure remain worrying. Here we observe not only an element that disrupts the logic to which we aspire, but also one that perverts institutional incentives. Generalized impunity continues to prevail, since it is measured significant levels of lack of effective response prevail. However, when we analyze it by crime, we can find states in which their prioritization policies possibly begin to see some changes. These and other findings can be found in the presentation and in the report that we invite you to review. I will let Anders Matthews to share some of the insights from the USA. Please, Matthews, share, share your views.
Thank you so much. Hi, everyone. As mentioned, my name is Anders Mantius. I'm the Deputy Director in the Office of Governance, Rights, and Citizen Security with the U.S. Agency for International Development here at the U.S. Embassy in Mexico City. First and foremost, I want to thank Mexico Evalua for the invitation, as well as everyone else for their participation today. It's really an honor to be here with all of you. For USAID specifically, rule of law is fundamental to our development and security objectives here in Mission Mexico. And we've worked hand in hand with Mexican government institutions and civil society on this topic for more than 10 years. Overall, our rule of law programs work to promote efficient and transparent systems that put users and citizens at the center of our initiatives. We also believe in using innovative and sustainable approaches to help advance country-specific justice needs in collaboration with and under the leadership of local partners. At USAID, we're proud to support Mexico Evalua in its effort to promote data-informed public policy. Evidence-based solutions are a key element in USAID's approach to deliver people-centered justice, and Hallazgos and Mexico Evalua have greatly contributed to this strategy. Over the past 10 years, Hallazgos has been an incredibly helpful reference for state operators, academia, and civil society in the country, really providing constructive feedback and pinpointing areas for improvement in Mexico's justice system. So with that, I want to thank Mexico Evalua again and everyone else for your time. I hope you enjoy the presentation and I look forward to the discussion. Gracias.
Thank you so much, Matthews. We're very happy with the results we have until today and also for the support of USAID. Before giving the floor for the presentation and conversation, I want to introduce you to the experts who are with us today. Michael Reed Hurtado is the Director of Operations of the Guernica Center for International Justice. He's a Colombian US lawyer and journalist with over 25 years of experience in the fields of human rights, criminal justice, and humanitarian action, mainly in Latin America, with sporadic work in Asia and Africa. He teaches at Georgetown University, focusing on state crime dynamics and causes of collective violence, denialism and the sociology of lying, and practical dimensions of human rights, transitional justice, and negotiated peace settlements. As a journalist, he's also a regular contributor of written op-eds in Spanish language news media. Welcome, Michael Reed Hurtado. Jaime Chavez Alor is the executive director of Cyrus Vance Center for International Justice. Before joining the Vance Center, Jaime worked in the three branches of the Mexican federal government. He received his law degree from Escuela Libre de Derecho in Mexico City and an LLM from Columbia Law School, where he graduated as a Harlan Fiske Stone Scholar and received the Parker School of Foreign and Comparative Law Recognition of Achievement. Jaime has authored and co-authored several articles and books on human rights, conflict of interest, corruption, and democratic participation. Welcome, Jaime. Adriana Garcia is an expert advisor of the Rule of Law Impact Lab at Stanford Law School. He's an experienced lawyer and legal scholar with a focus on the rule of law, human rights reparations, and judicial independence. With a career spanning prestigious organizations and academic institutions, Adriana has played a significant role in promoting judicial independence and protecting human rights, particularly in Latin America. Adriana holds a doctorate from the University of Chicago Law School, a Juris Doctor degree from the ITAM, an LLM from the University of Chicago, and a master's degree from the Complutense University of Spain. Due to a special situation, Adriana could not be live with us today, but she left her contributions. Finally, I want to thank the foundations that make this evaluation, this conversation, and this work possible. From my heart, really, thanks to USAID, thanks to the Nauman Foundation for all those years of support, help, and to make this possible. And thanks to the Justice Program and Communications team of Mexico Evalúa. I'm really proud of all the work that you have put together for having this great analysis today. Now I leave the floor to my colleague, Cristel Rosales, coordinator of the Justice Program, to make an executive presentation of our report. Please, Cristel, go ahead.
Thank you, Mariana. Good morning and afternoon to those who are with us. First, my thanks to the foundations that support us, thanks to the colleagues who have made a space to join us, and thanks to the extraordinary team of the Justice Program that, with a lot of effort, make this possible. The purpose of this presentation is to gather some elements on the main findings of the most recent evaluation of criminal justice in Mexico. You can review it on the Mexico Evalúa website in its Spanish version, as well as in English. I invite you to retrieve these main elements to serve as a framework for the conversation we will have in a few moments. As Mariana commented, the whole world and Mexico are going through simultaneous crises, migration flows, changes in economic prices, budget restrictions, climate change, polarization, among others, which in turn are combined with social demands and discontent on the part of the population. This context makes the challenges even more complex and greater, considering that the justice model that has been adopted has not been able to put people at the center. It imposes us on the urgent need to find new ways to achieve this in the immediate term, as well as to find strategies that guarantee structural changes in the medium term. With this in mind, let's start with the presentation. Let us briefly recall that for 11 years, Mexico Evalúa has been developing an evaluation on criminal justice. This is fed with official information provided by the different bodies involved in the justice sector. And although it is subject to the availability and quality of public information, the truth is that we are promoting the development of better statistical information that allow us to have indicators that reflect more accurately what people as victims or defendants experience during the entire criminal process. This timeline, if you could help me please with the presentation. Okay, thank you. This timeline shows us that the efforts to transform criminal justice in our country date back at least 16 years ago, when a constitutional reform took place that, through the umbrella of an adversarial system, sought to make criminal processes public and open, that the rights of victims and accused were a priority, that the system was able to handle minor cases through expeditions, exits, while priority cases would have the necessary resources and efforts. A justice that focuses on truth and the restitution of damage, and not only on punishment. Since then to date, we have had various reforms, as the work of the National Guard as a military first responder in crime investigation tasks, and the expansion of automatic mandatory pretrial detention, a period in which the practical operation of that original reform was effectively a national priority. Therefore, not only have efforts been left adrift, but without correcting existing spaces of arbitrariness or discretion. Changes have been taking place that even go in the opposite direction. Let's see. 4 important background information. The first one, people's trust in justice institutions has shown a negative trend, except for a state where some changes can be seen. The national average shows a decline. On the other hand, people's perception of corruption regarding these justice institutions, prosecutors, judges, police, has increased, showing that the institutions that are closest to the population are those that are perceived as most corrupt. The third one, dark figure, that means crimes that are not reported or investigated by the authorities, has not changed in 10 years. 94% of crimes are not investigated. Most of the population doesn't go to the authorities to report, mainly because they don't trust the authorities or because they believe that it will not be of any use. While among the crimes that are reported to the authorities, cases of theft or property crimes prevail as the highest volume, followed by cases of domestic violence. Cases of lethal violence or others that represent serious violations of human rights represent a very small part of what the authorities receive. This makes evident the need to adopt differentiated strategies that ensure that the latter will not be left unattended. If the system is currently saturated with low levels of crime reporting, reducing the dark figure will only mean more demand. Let's go to this visualization. Here we have 3 main ideas. First of all, not all crimes can be monitored. 12% don't lead to investigation processes that make it easier to identify what happened to them. The second one, half of the reported cases are ongoing, still in progress. And the third one, Meanwhile, among the main resolutions are the use of archive or the abstention from investigating resolutions that can represent spaces of impunity. The cases that are resolved by alternative means or by trial present very low proportions, only almost 7% and less than 1%. Let's see. So, what is the effective response from the justice system? General impunity, that which is include amounts to 96%, with most states at levels above 90%. Even the states that present the lowest levels are between 70 and 90%. When we review the effectiveness by crime, crimes against life, freedom, and integrity of people, as well as crimes of specific violence against women or children, such as homicides, femicides, forced disappearances, sexual abuse, or rape, present levels of intolerable impunity. In addition to this flow of a low effective response, what does the evaluation tell us about the priorities of institutions and the protection of rights? On the one hand, we identify that the system continues to be extremely dependent on crimes that are committed in flagrante delicto. That is, a large part of the cases that come to court correspond to these crimes. 4 out of 10 in the states and 1 out of 2 at the federal level. However, there are states in which the proportion are much higher. Let's see Mexico City, Colima, or the state of Mexico. Likewise, arrests continue to be observed that don't comply with due process, and it is worth saying, they open spaces of impunity from that first moment, since when cases are brought to court, they cannot be sustained. And what about the possibility of carrying out the processes in freedom? Even though pretrial detention should be exceptional, it has become the rule. 65% of precautionary measures are in detention, most of them automatically, without risk analysis to justify it. On the other hand, the units that supervise the cases in freedom have shown a high effectiveness. 99% of the cases with precautionary measures in freedom conclude successfully, without the abduction of people and without risks for the victims. 3 factors about the duration of the processes that imply the possibility of prompt justice. The first one, the Constitution established that people have the right to be tried within a maximum period of 1 year, but the average duration of a criminal process that concludes in trial is 486 days. The second one, criminal trials involving female defendants are longer, a question that merits analysis of why, what is happening there. And the third one, the use of pretrial detention is not only widespread, but also has a significant impact on people, since its average duration is 206 days. This without any compensation to the people and their families who may have been affected by this measure. 2 final thoughts before moving on to recommendations. The first one, the development of a military security model without the construction of civilian capabilities does have an impact on the way prevention and reaction are developed through arrests, intelligence, and investigations. And the second one, the bodies that legally represent the victims are the institutions with the least support and with a clear disadvantage in providing assistance. Even when with this, states like Nuevo León make an effort to improve their attention capacity. Now let's move on the last slide. Our recommendations. These are some of the findings that present a comprehensive picture of criminal justice and that should be inputs for current national discussions. Here we leave some of the recommendations that we put forward in the report, such as the need to articulate a national policy which comprehends public security and criminal justice. Currently, they are worlds that don't converse with each other and whose connection must be guided by the protection of rights. The need to transform the justice prosecution model. As we have seen in the diagnosis, the main and widest areas of impunity are concentrated in the first response by police or National Guard and prosecutors. Furthermore, we have a non-existent Attorney General Office whose task is to protect us from the complex criminal phenomena and markets that now cover every corner of the country, transcending borders and operating with total permissiveness, which seriously affects the possibility of a rule of law. Alternative justice, which depends on the prosecutor's offices and could resolve between 35 or 50% of the conflict, is totally wasted. The temptation has taken place to further restrict freedoms and leaves people's rights invisible by expanding pretrial detention and abandoning public defenders for victims and accused. Let's just look at the proportion of people in prison without a sentence and the budget space for those instances. Rather than correcting these structural deficiencies, people-centered justice is possible through collaborative exercises with the population and responding their main needs and demands. An example of how this is possible can be found on our Justice Network website. We must continue these efforts and replicate them in the country. It is a clear way to recover lost spaces of trust. And finally, under this evidence, it is impossible to say that the system worked as expected. However, it is clear to observe that the major problems of impunity are very clear in the operation of the security forces and the prosecutors' offices, since the cases that reach the courts represent a very tiny proportion. For this reason, and now I would love to hear the perspectives from our colleagues, any reform that seeks to make justice more effective must keep in mind this panorama and offer solutions to those spaces of discretion, arbitrariness, or corruption, and even perhaps incompetence that are present and whose solution is in a very different place than those proposed in the constitutional reform. Thank you very much for your attention. Now I turn the floor to our guest, and Maria Jose Salcedo from the Nauman Foundation, who will guide the conversation. Very welcome.
Thank you, Crystal, for that presentation. And thank you, everyone watching us and streaming this online, wherever in the world you're joining this conversation. I am very happy to be moderating this session, since I believe that the topics in Mexico are important and relevant, internationally speaking, especially when it's in the topics of our justice system. So the name of this event is about the presentation of hallazgos or findings, and what are the main game changers to improve criminal justice and access to justice in Mexico. We know that this is a huge topic, and this is a topic where all of the other problems, as Christelle mentioned, migration, crime, and so on, really are the core in the problems of Mexico. So we know that Mexico, as Cristel just mentioned, has implemented reforms and policies to transform the criminal justice system to make it more effective and accessible to individuals, as well as guarantee the protection of our human rights and people's rights in the country. And these new reforms have been proposed to solve all problems related to the inefficiency of the system. However, they could really jeopardize the achievements or hinder the progress that we have already been moving on towards human rights approach. I'm very happy to be today with Michael Reed, as Mariana already introduced them, Adriana Garcia, and Jaime Chavez. I just want to briefly introduce myself. I'm Maria Jose Salcedo. I have been working as project coordinator at the Friedrich Naumann Foundation, which is a German worldwide organization. We are based here in Mexico City, where we have an office. I have been working here for the past 5 years, developing strategic partnerships with different civil society organizations in the country. And we do a lot of roundtables between decision makers, international cooperation agencies, academics, to figure out how to find best practices and solve different topics, just as the one today in terms of our justice system. So I'm thrilled to be moderating this session. And I would have probably the first question for everyone. We will go first with Adriana, then with Michael, and then with Jaime, if that's okay. And the first question that I would have for this session would be, based on the results from Hallazgos of 2022 that Cristel previously mentioned, from your perspectives as experts, which changes in the criminal justice need to be implemented to not wait years to see more changes or enhanced results? It would be very interesting to hear from you, maybe some lessons learned or best practices from other countries or different contexts that have successfully and steadily reduced criminal impunity through legal frameworks, or even the use of technology, and maybe if that could be applied in Mexico. So we go first with Adriana, and then we would go with Michael. Each of you will have 6 minutes for this first round. So, Adriana.
Hello, everyone. First of all, I want to apologize for not being able to join you live in this session. Unfortunately, I was called for jury duty, but I really wanted to participate in this great exercise of analysis of our criminal legal system. Thank you, Mariana. Thank you, Cristel, for organizing and inviting us to this important panel. So I want to start my intervention with my findings, with my main findings of the Hallazgos report. So, having thoroughly reviewed the Hallazgos report by Mexico Evalúa, I am profoundly concerned about the current state of the criminal justice system in Mexico. The report highlights several critical issues that require immediate attention. So, thank you so much for the report. Now, this is super important in terms of policy making and in terms of improvement of our judicial system. So one of the most alarming findings that I found in the study, I'm a lawyer, so I'm biased towards these specific findings, is the decline in citizen trust in justice institutions over the past decade. This erosion of trust poses a significant threat to the legitimacy and effectiveness of the entire judicial system. It undermines the rule of law, and it threatens democracy in general. The second finding that I found very interesting is that the report reveals a high perception of corruption within the justice systems, right? And especially the definition used in the report of corruption was very important in light of what I will discuss later on voting for judges. So corruption is defined as the presence of acts, processes, or individuals open to accepting benefits in exchange of privileges. So just keep in mind this definition when we talk about voting for judges. The third finding that it's super important to us is that the report documents continuous violations of rights experienced by both accused persons and victims during criminal proceedings, right? So both parties of the criminal justice system feel threatened in their rights when starting a criminal investigation or trial. So I want to analyze these findings in light of the recent proposal being discussed in the Mexican Congress regarding the election of judges by popular vote. To do this, I will use a recent report that we issued at the Rule of Law Impact Lab of Stanford Law School, in which we examined the implications of such a proposal based on the U.S. experience with judicial elections. Because in the US, we have judicial elections at the local level in most of the states. So when analyzing the literature on judicial elections in the US, we found first that public trust in the legal system diminishes when judges are elected because people perceive their judges to be biased towards those who finance their campaigns, such as companies, interest groups, or powerful individuals. And moreover, it is not only a perception, but some studies show that judges decide in favor of the people who financed their campaigns, right? So this is not only perception, this is an actual bias that has been found when people vote for judges. The second finding, in light of the US experience, is that judges facing re-election tend to impose harsher sanctions, including more frequent use of the death penalty as elections approach, right? So this trend is driven by the public perception that establishes that justice equals punishment, right? So this leads judges to issue more severe sentences to appear tough on crime and get votes, right? Because they are looking for the approval of the people and not the compliance with the law. So if we combine Hallazgos with the US experience now, specifically with these two findings, we have that first, the declining citizen trust in Mexico's justice institutions aligns with the US finding that public trust diminishes when judges are perceived to be biased towards campaign financiers, for example. This perception of bias undermines the credibility and fairness of the judiciary, further exacerbating the existing mistrust of Mexico's justice system. So we are not only not fixing the problems that we have, but we are increasing the problems that we are already facing in the criminal justice system. Second, the high perception of corruption in Mexico is paralleled by the US experience where judicial elections create conflicts of interest, leading to perceptions of bias and actual corruption. Judges in the US who seek re-election are seen as potentially influenced by those who finance their campaigns, which could similarly undermine judicial integrity in Mexico. So people in Mexico are already distrusting their judges, right? Now that they know that judges will be looking for money, looking for sponsors of their campaigns, now this perception of corruption will totally increase, right? And finally, the continuous violations of rights, that we mentioned in Mexico's criminal justice system are likely to worsen under an electoral system for judges, right? So the US experience shows that judges facing re-election tend to impose harsher sanctions to appear tough on crime. driven by public perception that it creates justice with punishment. This can lead to more severe penalties, including the increased use of the death penalty, right? So this finding of Hallazgos saying that rights of victims and accused people are being violated will be exacerbated too by voting for judges. Because if judges want people to like them, then they will tend to impose harsher penalties, again, violating sometimes the rights of the accused. So in conclusion, the proposed judicial elections in Mexico could amplify the problems identified in the Hallazgos report. The electoral process for judges is likely to increase public distrust, perpetuate perceptions of corruption, and exacerbate rights violations, rather than addressing these critical issues, right? Instead of increasing accountability and trust in the justice system, it could lead to greater distrust, more corruption, and more erosion of the judicial independence. As the conclusions of the Hallazgos report establish, it is essential to prioritize reforms that strengthen the criminal legal system, specifically the judiciary's independence and integrity, ensuring that judges can make fair and impartial decisions without undue influence from political or financial interests. Finally, I want to conclude this short intervention by saying that the Hallazgos effort is crucial for providing objective and significant data to inform policy decisions and improve the justice system. So I would totally suggest to use the Hallazgos report to analyze also these coming proposals to amend our constitution, and that which objective is to improve our legal system. No? And we should take into consideration what's happening with our criminal justice system, right? And this is Hallazgos. Hallazgos is telling us, look at the big picture. This is what is already happening. Is this going to fix what we already found that has to be fixed or not? So thank you again. Thank you for Hallazgos, and happy to see what the rest of the panelists are going to say. Thank you.
Thank you. So that was Adriana Garcia. She's expert advisor, rule of law at the Impact Lab in Stanford Law School. And now I would like to go and ask the same question to Michael Reed, the Director of Operation at Guernica Center.
Thank you, Maria Jose, and it's a pleasure to be with all of you. I would also like to start just simply highlighting a couple of the findings that arise from the report that I think are crucial in setting up the answer. So the first is just to kind of put some dimensions, and Cristel addressed it, but I just want to underscore it. We're talking about a system that is seeing about 2 million complaints that are being added every year, as I understand it, and as I understood the report. That in itself is something that should concern us, right? What are we trying to do? If we consider as well the average duration and the different dispositions of the cases, there is inherently a backlog that just builds up. And we're talking about millions and millions of cases. So this is a case management issue, and this should also be a policy question as to, are we just funneling these cases through the system? And as long as they are within the closed doors of the system, we're okay with them being there? Or as a society, are we concerned as to what is being funneled into the criminal justice system, and also what is just staying and just kind of sticking and dying within those swampy lands of the criminal justice system, and very dark lands of the criminal justice system? Because we just get a sense of the cases that leave, some of them because they're innocent pleas, and then those that end up in convictions. But the bulk of the millions of cases, they just rest within the criminal justice system. And that number just keeps getting bigger and bigger and bigger. And it's quite unmanageable. And again, that is a discussion that needs to be had. I know that you highlight your concern because of the dark numbers or the cifra negra or the unreported crime. I don't think that the unreported crime that you are registering is much different than the one seen in different societies. Even in the United States, the number of unreported crime is huge. In the rest of Latin America, it's immense, and we really don't have great ways of measuring what it is there. Now, again, regardless of the numbers of unreported crime, the numbers of reported crime that Mexico is seeing are just immense, and that's something to reflect. Secondly, you speak in your normative system and on a lot of forums about selection and how strategic selection is. However, once again, the findings report says that selection is principally being led not by strategic criteria, it's being led by convenience. It's being led by whatever we can get into the system and visibly see there. And that, to some extent, is present in the types of crime that we are seeing coming through the system. And that's largely theft. Theft is really occupying a huge percentage. And within that category of theft, we've got different types of conduct. And I think it would be really important to evaluate whether we want theft to really be clogging down the system. There are some cases of theft that definitely need to be there, but there's other cases of theft that could probably have a different disposition. The second huge bunch of cases are under that name of intrafamilial violence, or these are situations occurring within, I suppose, a wide family network. Again, there are some interesting experiences on what to do with prevention, with measures that are short of criminal justice system that could tend to those numbers there. Dealing with prevention, dealing with corrective matters, but everything short of criminal law should probably be something that we pay attention to. And then you have a bunch of crimes that are under, I suppose, the general name of battery or personal injury type crimes. They're not attempted homicides, they're a little bit lower. But we again have a social problem. We have people using knives. We have people using other types of objects to generate harm on other individuals. And again, this is a type of intervention that could also go via police administrative measures, and not everything needs to go via the criminal justice system. Some of the charts also reflect the element of threats. And again, quite difficult to have a criminal justice system that is seeing so many threats being channeled as a criminal complaint. And then largely, and very importantly, and this is true in most of Latin America, we've got petty crime offenses really occupying the system. And again, before we get to the criminal justice intervention, there are so many things to be done from a public health perspective, from a social perspective, from a police perspective, from a community perspective, that could probably be measures that are of attention. Let me stop there as far as a first reaction of what we have in the numbers and what is being channeled through the criminal justice system, because I think understanding that could really help us use the criminal justice system as what it is supposed to be, that ultima ratio of the state response. And let me end with just a few very simple points. The first one is probably quite basic, but I think it gets lost in the very complex reads. The majority of these cases, the majority of what it is to have criminal justice operating is not federal, it's local, it's state. And very often the discussions get lost at the federal level with federal discussions and the president discussing issues and having that huge discussion that concentrates the nation. And we forget about those particularities of what is happening in each one of the states, and the fact that the analysis at the state level is always going to be different from state to state. I think the report of Mexico Evalúa does a great job to remind us, page after page, that we need to get into the state dynamics. because they don't respond to the same logic. And the relationship of a governor to the justice system in that particular state is going to vary from Nayarit to Coahuila to Aguascalientes. And we need to get into those local realities. The bulk of the administration of criminal justice does not take place at the federal level. It takes place at the local level. And those discussions are not being had. Again, I know it's a very simple point, but I'm afraid these simple points do get lost. A second very basic point, and I think I'm up with time, is I think reform, and this is true throughout Latin America, is less about laws and a lot more about practice. And again, there we tend to forget about practice because practice is dynamic. Practice is about culture. We can have cultures that are very norm seeking and norm affirming and all that, but where the practice is really far away from what the norm is going to be. In my native Colombia, this is true. And from what I know of Mexico and I've been able to observe, I also think this is true. However, over 90% of the discussions concentrate on norms, whether it's decrees, regulatory mechanisms, or laws, and so forth. And we really should be spending a lot more time on the practices, both public practices as well as the very subreptitious practices that are there. And for future conversation, let me just add the last point. That we call corruption is a lot of things. So it is also very important to get into the discussion as to what we are talking about. Corruption is a very ambiguous level. It is a really difficult issue to understand and to name. And the fact that we say that the justice system is corrupt is great, but we need to get into thicker descriptive mode in order to understand what the causal mechanisms are and how we can affect those practices. As is right now, all we are saying is a bunch of judges are corrupt. The solution, therefore, is to get rid of those judges. The solution presented is we're going to elect those individuals. That, as already has been said, appears to be a really bad answer to a problem that exists. And again, let me stop there. This last point, I hope that we're able to speak of a little bit more. And that, again, is the very simple point of corruption is a lot of things. Let's understand what we are talking about. Thanks.
And thank you, Michael. And we will dive into this new reform. But first, I would like to introduce also Jaime Chavez, who is Executive Director of Cyrus R. Vance Center for International Justice. We have up to 6 minutes, and then we will dive into the conversation. Thanks, Jaime.
Thank you, Maria Jose. First of all, thank you for the invitation. I'm thrilled to be here. I want to congratulate the whole team of Mexico Evalúa for the publication of this important and informative document. Congratulations on this 10-year effort that serves as a witness to the criminal justice system in Mexico. And it's also important to mention and recognize your effort to translate this report into English, which I know is not an easy task, but it is fundamental to reach audiences beyond Mexico and involve the international community in what should be a joint effort to improve the criminal justice and access to justice in Mexico. I completely agree with what Michael was saying. When I was introduced the first time, I worked at the Senate, I worked at the Attorney General's office. And I was working at the Senate when the constitutional reform to make the procedural criminal law a national matter was passed. I was in the Senate working in the Justice Committee when the National Code for Criminal Procedure was created. And there was so much effort onto what to put in the code and how should it be put. And the different text options. The US Embassy helped a lot at that moment with technical support. And what it was very important for the senators, for the technical team, was to see other realities. The embassy organized through OPDAT study tours to the US, to Chile, to Colombia. And one of the things that we were told was, you need to be very careful because Colombia is an example of a country that made a change to the custodial system and it's collapsed. Here is a good experience of Chile, And this is what you should try to replicate. Of course, Chile is a much more smaller country, different reality. But I think that the focus was always on what does the law says. And we really didn't understand that the key was not what the law was going to say, but the whole system and the different authorities that were going to be involved, the capacity and independence of the authorities. And that was, now I understand the big difference between Mexico and Colombia and Chile, where we have a good experience of how this change to an accusatorial system was implemented. And this system is closely related to corruption and to trust. So I don't think it's a matter of rules, because rules can be perfectible. The legislation, the text of the code has been changed, but for sure that is not the main problem. And I think that the report understands this very well. I work at the Van Center. Our mission is to advance global justice by engaging lawyers across borders to support civil society around the world. And in the work that we have done with civil society organizations, we've seen that the importance of the criminal justice system is crucial for a country. It's relevant for security, for human rights violations, for anti-corruption efforts. In our anti-corruption work, we haven't found a country with a weak criminal justice with low corruption. On the contrary, there's more corruption, there's more impunity. In countries where the criminal justice system advances its goals, including its prevention and its function as a deterrent mechanism, there's also less corruption. And I completely agree that corruption means a lot of things. We also have seen that the trust on the system is key. And judicial independence and integrity are crucial to ensure trust from citizens in the justice system. Independent judges appointed in a merit-based system with a secure professional development and training are fundamental for trust and for a functional system. I read this report with a lot of attention, and I think it's a fundamental tool not only for anyone in Mexico doing any work related to criminal justice system, but also for students and those members of the legal community doing work on anything related to justice reform. This is a fundamental tool for organizations and other actors doing work in Mexico. It is very clear in three aspects, or in many aspects, but I want to underscore three. First, a justice system, particularly a criminal justice system, is not only about the judges. In Mexico, I think that the discussion tends to gravitate toward what are the judges doing and what is happening with the judiciary. And this report is very clear to show that even when the judges are key actors, yes, but there are other justice operators that are in desperate need of attention. The accusatory system was never about the judges. I remember very well US prosecutors telling us, your criminal justice system will be successful if you have only 8% of the cases being heard by judges. And that is not the case. Our number is very far from that. So we need to understand that not everything needs to be solved by a judge. And that's where part of the importance of how this report is putting this information very clear is fundamental. The second point is that I think we agree, and this report shows that there is a desperate need for a justice reform in Mexico. But this justice reform shouldn't be about how we appoint judges or if we should elect judges. This is a matter of efficacy, effectiveness, the duration of the process, the sentencing, the prison system, which makes the point, and the report makes this point very well, the importance of delineating structural causes for why the Mexican criminal justice is where it is. The report has a recommendation section that I thought was very, very important. And I can't underscore how important this section should be in terms of authorities considering it for the next steps of what they need to do. Other recommendations are relevant, but I really like the one that talks about the incapacity to provide an effective response. you showed the numbers of 400 and something days that would take for a person to have a response to a very important matter. And what we have seen in many countries is that the incapacity of the justice system to provide a response has led to major social unrest or extreme drastic measures seen as the only way to protect the population. And just to mention an example, we have El Salvador with a completely ineffective justice system, and now it's the safest country in the world, but not because of good reasons. And the last topic that I would like to underscore is how unfair the federal system in Mexico is. A minority of states have positive indicators, but even these positive indicators are very low, and most of the states show a very weak performance. And the efforts of a real justice reform should go towards standardizing capacities, resources, and to make efforts to do these local justice systems capable and independent. For this, of course, we need political will to make these changes happen. And maybe I will leave it here right now, but I would like to talk about later on how, at least we have one example how an international mechanism that focused on independence and capacity helped a country in the region to strengthen their judicial system. Thank you very much.
Thank you, Jaime. And I would just like to tell everyone who's watching us, if you have questions, please leave them on the chat so that we can also check them and ask them later for the Q&A. And if Michael and Jaime agree, I would like to, after listening to what you said, divide this conversation in two sections. So the first one would be to one of the questions that we received, which is, what specific measures or reforms do you believe would be most effective in creating an efficient system? And this is something that you both mentioned in different points, like the system has this overload. You mentioned, Michael, about things that the police has to do, but not every judge has to do because of this petty crime overload. You also both spoke about the laws are there, but in the practice, we need this culture. You also both spoke about the state focus and how we also need to dive more into these decentralized system. And last but not least, I would like for you to end on the note of corruption so that we can then dive into the proposed reform on what Adriana was mentioning on the direct vote of judges. So yeah, if any of you would like to begin on this first question, maybe Michael or Jaime, whoever wants to go in. Michael.
Jaime, por favor.
Okay, Jaime, your turn.
So yeah, I mean, in terms of the system, I think it has been very clear in Mexico that the federal judiciary is not the issue. In fact, the federal judiciary in Mexico has been a good example in the region for what a strong judicial civil service should look like. There have been many efforts to professionalize judges, magistrates. The judicial civil service starts way before becoming a judge. And that has been a good example in the region. So the criminal justice system is the issue is not the federal judiciary. We have the Attorney General's offices that in 2016 we had this 2014 we had this reform to have a federal Attorney General's office that was independent from the executive, an autonomous body, and then states followed. But this was never thought in a way that would be harmonized with the accusatorial system. And what was discussed before is that it would have been a good idea for the new independent Attorney General's office be in charge of implementing the accusatorial system and leave the former PGR as the entity in charge of closing all the matters in the old system. The fact that we were late to train police officers and other actors within the criminal justice system has been key to what we see now in Hallazgos, which is a complete failure of the criminal justice system to provide an effective response to society. And if that's true for the federal system, because the Attorney General's office at the federal level has many opportunities, it is very true for the state level, where we don't have independent judiciaries for the most part. We don't have capable judiciaries. We have magistrates who are directly appointed by the governors, based not on a merit system based system, but on political considerations, where the Attorney General's office responds directly to the will of the governor or a group of power, which is not functioning as an independent matter. That we don't have professionalized investigative police, where we don't have the scientific investigation methods that we should for the criminal justice system to work. And the fact that all of this is left for every state to decide, even when we have the national code for procedures, every state organizes their system in a different way. And the differences that Hallazgos show are based on those differences that we haven't been able to establish in a standardized way. And it is true that there's corruption in the judiciary. And I think that would be lying if we said that that doesn't happen. It does happen. It happened a lot at the state level. And the federal judiciary is not exempt from corruption. But the solution is not stating that we are going to get rid of all the judges and appoint new ones, electing them in popular vote. What has happened in different countries that have strengthened their judicial system is, yes, fight the corruption, but at the same time, strengthen their integrity mechanisms, strengthen their judicial civil service in order to make sure that the judges that are there are following ethical rules, are professionalized. And there's a phrase that I really like from a judge, which we have done a lot of work in Latin America. It says that a professionalized judge is a powerful judge. And that's very true, because in many of the states in Mexico, we see that one of the issues is that they haven't really understand completely how the accusatorial system should be working. And that's an issue, and that's a risk when you have judges that are supposedly professionalized. They don't understand, and now we want to have judges. The last thing that the president said is that he doesn't agree with the requirement of having at least 5 years of experience as a lawyer. So you're going to have like recent graduate lawyers with the possibility of becoming judges. And I have nothing against the recent graduate lawyers, but judges are highly professionalized, technical lawyers. And if we don't have judges who understand the system, and the criminal justice system is a very complex one, but there are other justice systems, we're going to start having an issue. And if that becomes a problem, then there's going to be even more corruption. And I'm not referring to corruption only in the way of people bribing the judges, but also a judge who's not really independent because they're not able to decide cases based on the law, on the jurisprudence and legal criteria. They also become corrupt because they will be deciding based in different considerations. And this is very dangerous. And this could have very, very important repercussions. I think that it is fundamental to understand that, yes, we need a reform, a justice reform. But if we really want this to be effective, we need to take what has worked in the federal system and apply it to standardize the state system. If we could have a constitutional reform to say that all the states should follow the rules that the federation has for the judicial civil service, that would be a very big step, because we would be moving towards a merits-based system, professionalizing, making sure that the different justice operators in the different states have the capacity, have the independence, have the resources, which is also very, very important to say. If we really want to reform the justice system, we need to make sure that the local systems have the resources they need. And this is a percentage of the budget, or making sure that they have the economic resources.
Yes. Thank you, Jaime. Sorry, I was keeping track of time, and I wanted to make sure that Michael has still some time so that we can also go to the other question. Michael, if you want to add also something regarding how can we make it more efficient based on the points that you also mentioned, and also what Jaime just proposed.
Sure, and I will help you to also trying to keep time this time. Perhaps before going into the operation of the criminal justice system, for me, and thinking of reform, I always try to have the reflection as to how do we get here, right? One of the problems that we have is that too many things are coming to the criminal justice system. And that's a discussion that generally politicians do not want to have. And basically, it's because the criminal legal expression has become the way of addressing complex problems that appear to not have a solution. So if I have a problem that is public health oriented and I can't resolve it, I can very expressively resolve it, making something a crime and saying that I'm going to punish it. If I have very high levels of violence within the Mexican family, instead of addressing what is happening at that level, trying to do prevention, trying to do social work, I say, I am going to come out with harsh measures in order to penalize that conduct, and therefore this is my response. So I think in order to make the system efficient, the first thing you need to do is review the over-criminalization of problems. That does not mean that things do not need to be criminalized. And let me insist, I do think that there are crimes that occur within those settings that need a criminal legal response. But what cannot happen is that everything gets fed into the criminal justice system. So the first thing that needs to be done, without a doubt, is previous, and it goes to the substantive criminal law. And that is, we need to really rationalize the conduct that we consider to be criminal. Very quickly, as we were speaking, I just kind of pulled down the the Coahuila Criminal Code, which was 450 some articles, 80% of which are crimes. Aguascalientes is a little bit less, but we're still talking about all kinds of crimes. And there again, the whole issue is it'd be really interesting to do a substantive exercise of how many of those crimes get used, right? Do we just have them as an expression of response to a complex problem? I criminalize the conduct. Don't worry about what happens to it afterwards. The issue is I have successfully used criminal law as a response to the problem. So rationalizing what we make criminal is fundamental. Secondly is, once we have kind of a rational repertoire of crime to go to, we do need to review something that throughout Latin America is a huge problem, and that is that the selective criteria of who gets fed into the criminal justice system isn't who commits the crime. Because, for example, with petty drug offenses, there is no doubt that there are a lot of petty drug offenses that are taking place in the middle class and upper class neighborhoods of Mexico. However, what's getting hit is the lower level and the lower echelon. So that selection of addressing urban marginality, not through social measures, but rather through criminal measures, is just growing and growing and growing. And again, since the response of the criminal system is punitive, all we have are these prison systems. And there again, look at the way the federal prison system is structured and look at the way the local prison system is structured. Overcrowding is affecting all of these individuals. And what you're doing is really warehousing a lot of individuals and actually amplifying many of the social problems that are taking place in urban marginal areas. So again, in order to make the system effective, and mind you, I haven't even been speaking of administration of justice. This is all previous to. One cannot all of a sudden put a lot of oil into the judges and all this type of system if what happens before isn't addressed. So if you are very serious about addressing a criminal justice reform, at the very least, and I'll keep it simple, one needs to start with the rationalization of what is criminal, and also with an examination of how the selection of what gets fed into the criminal justice system is taking place. And as of right now, in Mexico, as in most of Latin America, that has taken place with extreme discrimination against traditionally oppressed and discriminated sectors of our society. I would keep it there just to keep points simple and again, complement what has been said. Let me stop.
Thank you, Michael. Yeah, thank you for that. I just want to briefly sum it up before we go to the next question. And again, if you're watching us and you have any questions, please feel free to drop them on YouTube. So we talked about how the system is overload, like what needs to be considered as criminal in order to go through the system, as Michael said, like rationalization of it. Jaime also mentioned the examples of what happened in Colombia, Chile, what's happening in El Salvador. Again, we also have huge amounts of laws, but how does that translate in the practice? And of course, this huge definition that we have about corruption, and that Adriana was also mentioning it. So I want to jump in now to the future reform that we will probably be seeing in the next months. And the reforms to the judiciary come from claims of inefficiency of the system, as you have said, and about this claim corruption among judges that you also have been mentioning. Nevertheless, a lot of experts here in Mexico suggest how these reforms could diminish the rule of law in the country by eliminating the independence of the judiciary branch from a democracy with division of powers. I was listening to a podcast from the Reforma newspaper where they claimed, like, for example, how do we go from a division of powers to a fusion of powers? And I go back to what Michael was saying about how we have the laws and we have a constitution that guarantees the separation of powers. We all learn about it when we're children and kids and we go to primary school, the executive branch, the legislative, the judiciary branch, right? So we know about the separation of powers in the country and the importance of the checks and balances. So Mexico is clearly this new democracy with institutions that need to be strengthened and enhanced. But currently, by law and the Constitution, it offers a solid framework. But as you both have said, in practice, we need this culture. So the question for both of you is, what are the implications of this proposed reform, especially for the criminal justice system? And what could happen in terms of the processes? What is at stake? So I leave the question in case who wants to go first, Michael or Jaime.
Jaime will switch it up if it's okay.
Sounds good.
Sure. So again, I am like a broken record, but let me insist on the importance of specificity. Corruption is a lot of things. Corruption is a kickback. Corruption is a threat to a judge. Corruption is the offer of a payment. Corruption is a individual action, or it can be a very complicated collective action. And I think it's really important to identify what is it that we're trying to combat. If you are describing corruption as generalized, we're getting into collective dynamics, and one does not address corruption, which is individual in nature, in the same way that one addresses corruption in a collective dynamic. I think corruption in relationship to organized crime in administration of justice has to be addressed differently than corruption in a particular case where one individual has offered a kickback. I also think that, for example, we tend to concentrate more on the influence of organized crime because of the negative stereotype that obviously is attached to that socially. But we pay less attention to another type of very serious corruption, which is traditionally state capture. And that is where legitimate private interests completely change the rules of the game and use the system in their favor. For example, in Colombia, the influence of the financial and banking sector over who is a judge in the Supreme Court, in the civil chamber, is huge. And that is a very different case. It is very serious as well. But again, it has to be dealt with differently. The causal mechanisms to get to that we call corruption are very different in the different cases. So if one wants to be successful at it, I think the best issue is not to combat corruption largely, but rather to try to start identifying in very thick, descriptive ways, what is the problem that we're trying to attack, identify a causal mechanism, and affect that causal mechanism. Perhaps because of age, I think now that the best experiences in combating corruption are those that set themselves up to achieve measurable results. And I think this is true in the administration of justice in Mexico. It will be very different localized. It will be very different depending on the type of crime. I don't think that if what we're trying to address is corruption in relationship to the way the disposition of cases that involved interfamilial violence or battery is exactly the same than those that are dealing with homicides or those that are dealing with more complex trafficking type schemes. And it is really important to have adequate mechanisms that aptly respond, and that are functionally adequate to address the type of corruption that we are trying to combat. So again, particularity is absolutely fundamental in what we are trying to do. Let me leave it at that, and that way we can have a discussion.
Fantastic, thank you. And we go over with Jaime.
Thank you. So, considering what Michael said about the different meanings that corruption can have, I think the assessment that the president makes in terms of something is not working well with the judiciary is correct. However, the reform that he's proposing is not addressing those issues. It's a fallacy when he says that electing judges will be the way to address these issues. But I don't think that he's trying to solve these issues. I think that this reform is very directed towards gaining control of the judiciary, towards creating a new judiciary that is not necessarily check and balance to what the executive or the legislative wants to do. And this is especially true because his proposal to reform the judiciary is not isolated. He's also proposing to eliminate many of the constitutional autonomous bodies that were created starting 20 years ago as part of consolidating a democracy in which the president was not the person in charge of deciding everything about everything. So the National Institute for Transparency, the institutions created for energy, antitrust, the Human Rights Commission, and many other autonomous bodies were created to take out of the sphere of the executive branch key matters that were fundamental to a democracy. The judiciary has, at least in the Constitution, always been in a separate branch of power, has been independent. And we know that before the constitutional reform in 1994, this might not have been the case. But after December 1994, we had this new judiciary that has suffered a few constitutional reforms in order to strengthen the autonomy and the professionalization of judges and magistrates in Mexico, at least at the federal level. We do have issues with the judiciary, but these issues will not be solved with having people who are voted to become a judge who we don't know if they have the capacity, the independence, and the idea that the population in Mexico will be voting for hundreds of judges is just, first of all, I don't understand how that's actually going to work in reality. But that is not aimed to solve any of the problems that Hallazgos has shown, at least in the criminal justice system. That's aimed to have a judiciary that can be controlled through different means, having people proposed by the president and by the legislative branch participating in this process to be appointed federal judge, magistrate, Supreme Court justice, or at the state level. So it's a fallacy to say that the issues that exist and do exist in the judiciary will be solved with this proposal.
Thank you, Jaime. It is indeed a fallacy. And well, the topic of this event are the game changers to improve criminal justice and access to justice in Mexico. So I just want to have a small wrap up before we have a closure statement. So Adriana, for example, she also mentioned that based on the case of the US, when judges are publicly elected, there's actually a decrease in the trust because of maybe their interests when they have their own elections and so on. So this is something really interesting to watch, especially from cases like the US. You both also mentioned other international cases, which was part of the things that we wanted to cover today. You mentioned the case of El Salvador and how that cannot be, of course, considered. The case of Colombia, some good practices in Chile. I really, really take the petty crimes overload and this rationalization that Michael was speaking about. Also, both of your conceptions on corruption and what this means for the system, especially for the criminal justice system. And also what the states are actually doing. As Michael pointed out, the case of Coahuila, that there are some states that are changing completely to what in the federal level we are seeing. So, of course, this is something that whenever we speak of the criminal justice system, it's very important to also look at what some states are doing and hopefully going on the right track. So I just want to give you the floor, maybe 1 minute, if you have a close statement before we wrap up the conversation. Whoever wants to go first.
So let me kind of continue going on your idea, which I think is really important on comparative experiences. I too, when Colombia was beginning its process of exploring what is termed an adversarial system, we really have hybrids throughout Latin America, and again, it has a lot to do with the fact of that influence in the reforms of trying to do this modernization at the moment, and seeing how these new figures were working. And we were looking at different models, and yes, Chile was one where everybody was paying attention to, and I think it is interesting if justice systems worked in the abstract to look at that Chilean model. But it's really important to highlight the extreme difference in cultures that exist, bureaucratic cultures, even in legal cultures that exist between Chile and Colombia, and without a doubt in Mexico. Mexico, again, I want to highlight how very strange it is for us Latin Americans to really wrap our minds around and think about what a federal structure does to the administration of justice system. I'm trained as a lawyer in the United States as well. And it's very messy in the US with a couple of federal control issues. In Mexico, it's extremely messy. Maria Jose, you even spoke of decentralization, and those two systems don't necessarily go hand in hand. So when we're doing comparative processes, I think it is really important to, yes, we can benefit a lot from comparative processes, and I promote comparative processes much more than the internationalization of the norms and the transplantation of those norms. But Chile, I want to stress again, is very different. And above all, the biggest difference is the Chilean society is a relatively calm society. I just was amazed by the levels of homicides that go into the Chilean criminal justice system that need to be cleared. It becomes a doable task. It becomes a rational task. One can, in fact, take case per case and examine it and devote the resources. When you have 2 million cases coming into the criminal justice system and you have such small resources, and those resources aren't spread equally throughout the country, all of a sudden you have the amount of cases coming in. And mind you, we do have petty offenses, we do have little offenses. But the thing that is also clouding the system and filling the system up are homicides. Mexico is a very violent society. It is processing huge amount of cases, and many are not really being processed successfully. So in the comparative exercises, we need to be really careful with Uruguay's, with Chile, because they work nicely, but criminal justice systems do not operate in the abstract. Again, I make fairly simple points, but this point is huge. It's great to see what other colleagues have thought about and how these systems work in different places. But if we're to study, for example, how all the quick disposition of cases, such as the preacuerdos, the negotiations that take place, we need to take into consideration the dynamics of the Mexican society, the dynamics of power, of who's negotiating what, the levels of violence that are involved in there, not explicitly. And then see how that system works, because it's a system that is operating under extreme pressure with very violent crime as well. Now, there again is where I call on the rationalization. We need to figure out, when we say, how is the operation of the criminal justice system, it's going to operate differently with homicides. And one thing is a homicide between neighbors, and another is a homicide with complex criminal structures. We need to really get into the nitty-gritty of the specifics to be sure that we're seeing how the system is operating and relating to that type of crime. I will stop there. I really encourage comparative exercises, but do call attention on the importance of understanding the specificities of the dynamics that are in play. And in Mexico, these are really serious. Because as Mexico Evalúa's finding report says, these are the crimes. So the crimes that are clouding the system are, in fact, theft and so forth. The crimes that are affecting Mexican society are very different. And that's where we need to see how to get the criminal justice system to start operating in relationship to them. The discussion that is now being had in Mexico is all about the judges that are now the persons that are now judges, and the new people who are going to be judges that are going to be selected via electoral politics. For a country that has such problems with clientelism and patronage, it seems that electoral solutions to the problem of selection are the worst. Hopefully we can move beyond the discussion as to who is administering justice and actually look at the collective dimensions of how the administration of justice system works. And hopefully we can get to problems, as the Mexico Evalúa report allows us to do, of very specific dynamics in each state to see how the system is reacting to the different crimes and to the demand of a society that without a doubt is living extreme injustice. Thank you.
Thank you, Michael. And we are really running out of time, but Jaime, I want to leave you, of course, like 1 minute or maximum 2 for your final closure, especially maybe if you can dive into why is it so important for civil society organizations to support the research and proposals for the criminal justice system? We have up to 2 minutes. And you're on mute.
Thank you. I would very quickly say that the efforts that Mexico Evalúa has done for these hallazgos, 10 years of hallazgos, and the contributions of other civil organizations to understand how the criminal justice system is working in Mexico and the justice system in general are key to understand what is it that we need to do. I completely agree with Michael's point in terms of we need to see what other countries are doing, understanding the differences of why they are working in a different way, what has worked, what hasn't. And I would end by saying that in a country, Latin America, Guatemala, very close to Mexico, when there was an international effort between Guatemala and the UN to create the Commission Against Impunity in Guatemala, the efforts of the international experts working in Guatemala in terms of the criminal justice system were not directed towards how the judges were appointed, although that was an important aspect, how were prosecutors appointed, but all the efforts and the successes that the CICIG had in Guatemala, while it was successful, because that's a whole different story, were because they were strengthening the independence and the capacity of the justice operators in the country. So if we really want to do something in Mexico to improve our criminal justice system, the effort should go towards that, not debilitating what we already have and is functioning fairly well in some instances, although with areas of opportunities, but we need to strengthen independence and capacity. And I think that's the key. Thank you very much.
Thank you, Jaime. It has been a great conversation. I just want to really thank you and appreciate the passion that you have, and of course the mission that you're doing in your organizations. And of course, Adriana Garcia, who was with us, expert advisor, rule of law at the Impact Lab at Stanford Law School, Michael Reed, director of operation at Guernica Center, and Jaime Chavez, executive director at Band Center for International Justice. If you want to have a look at their organizations, please do. It was a pleasure for me to have this conversation. Thank you a lot. And I head over to Mariana, director of Mexico Evalúa. Thank you.
Thank you, Maria Jose. I'm really pleased with the event. I think that the moment couldn't be better. Right now is the moment to discuss justice. Right now is the moment to discuss criminal justice in Mexico. So I think it's great that we are putting into the conversation, into the public conversation, your inputs and your opinions. And definitely, I mean, evaluating justice is a very, very serious activity, and it's complex. We have to take into account the complexity, and each country has its complexity, and of course, what Mexico is going through in the crime rates. It's definitely a challenge that has to be considered whenever it's evaluated. But I don't want to take more time. You have already put a lot of your personal time, and I'm very thankful. Thank you, Cristel. Thank you, Maria Jose, and all our experts here. I think the next step is just to close the event. And have a great day.